person in custody with counsel Glenn Keene. We're set today in this matter for the sentencing portion of this case. Mr. Den pled guilty to count 5, possession with intent greater than 10 grams, but less than 50 grams, a Class D felony with having 4 other counts, manufacturing, delivering less than 3 grams, possession with intent greater than 50 grams, maintaining a trafficking place, and possession of paraphernalia as dismissed and read in. The court ordered a pre-sentence investigation report. The court has reviewed this report. I have notes, but I do not necessarily see that anything jumped out to me as needing to be changed as materially affecting the information to the court. Mr. Schmidt, did you receive and review the pre-sentence investigation report?
I did. I reviewed it. I have no corrections.
All right. Okay. Mr. Keene, did you go over that report with Mr. Dunn?
Yes, Your Honor. The only thing I would attempt to correct on page 7, it does talk about that he was revoked twice. I would note that later on that page, it talks about those being, 17 days of revocation. So I'd just point out it's a relatively short revocation versus revoke, go to prison. But other than that,
okay.
Nothing that we won't explain when we get to it.
All right. Thank you. And Mr. Keene, when I walked into the courtroom, I believe it is Mr. Dunn's daughter that was sitting up there and she had papers. Is she going to be providing a character statement today?
Your Honor, she provided a letter. She may end up making up her mind if she wishes to speak at the time, because I know she said it's hard for her.
All right. Well, then she has to make up her mind now, because I usually have the character references, witnesses, as well as the victims make their statement first to allow both counsel the opportunity to provide input or respond if there was something that needed to be addressed.
Okay. Do you want to talk or do you want to just use your letter?
All right.
Okay.
So you can come up here and have a seat at that black table over there. And you can state your full name if you wish, or I don't care if you want to use initials, that's fine too. If you're going to read your letter, which is totally appropriate and fine, please read it slowly so that the court reporter can take everything down. And I know that this is probably an emotional process for you, seeing your dad this way. So if you are affected by emotion, just take time, take some breath, and then go on, okay?
So state my name first.
Yes.
Jamie Den.
Okay, and it's Jamie, J-A-I-M-E.
J-A-M-I-E.
J-A-M, oh, so just the normal spelling, Jamie.
Yep.
Okay, all right. You may begin.
My name is Jamie Den. I am the daughter of Michael Den. I'm writing to you regarding the sentence of my father. I have a daughter who is 14 and a son who is 9. They haven't had a father figure but my father to look up to. My kids haven't listened to me ever, but they do listen to him. 2 years ago, I had a lot of problems with my son, where he was kicked out of summer school and off the bus. After spending all summer with him, he was a totally different kid that listens in school. I have had the privilege of growing up under my father's guidance and support, and I have witnessed firsthand the positive impact he has had on our family and community. My father has always been a source of strength and inspiration for me, and his dedication to our well-being has shaped me into the person I am today. I understand the seriousness of the situation, and I want to share some insights into my father's character and the positive impact he has had on our family and community. Michael Den has always been there for me or anyone that has ever asked, no matter what. Anyone that has ever asked anything from him, he has always gone out of his way to help with whatever they needed. Like an elderly woman, that husband left and went to another state, didn't have food or running water. My father went out of his way to get her water and bring her to town to make sure she had everything she needed. Even got a vehicle running for her so she had transport to go to town. Last winter, our neighbor wood froze to death because he got sick and couldn't cut wood to put in his wood stove. He ended up calling my father and asking for help. Not only did my father bring him wood, but he split it and stacked it, so the guy didn't have to do anything. Every morning, my father would go there and fill it up for him. I am sure your mind is already made up, but I have lived with my mother my whole life. When I was around my father, all he ever did was work. I hated the fact that he never did anything fun. It was always work. My older brother, for example, all he does is work too. He is getting old and his grandchildren need him. Not only for grandpa, but to be on the sidelines for their sport events, cheering them on. Thank you for taking the time to hear my letter and consider my opinion. I hope that my words will help you in making a fair and just decision.
Thank you, Ms. Den. And so you can understand, I don't make a decision. I need to hear from both of the attorneys, and I need to hear from Mr. Den and character references, as well as any victims if there are any involved. So I'm just letting you know that ahead of time. All right, argument and sentencing recommendation, Mr. Schmidt.
Thank you, Judge. I'm going to be arguing for the upper end of what DOC quoted in this one, which is 15 years initial confinement, 5 years extended supervision. I think that this is the correct sentence. I think the main purposes of sentencing the court should be looking at today should be incapacitation, specific deterrence, and protection of the community. I think this is the sentence that does not unduly depreciate the seriousness of the offense and is proportional to the sentences he's gotten in the past for similar behavior in the criminal history. This is a case where a confidential informant did a controlled buy while being surveilled by Deputy Bailey Mangan. He purchased a small amount from Mr. Den. You can hear them in the recording do this. Police got a search warrant. While staging for it, Mr. Den pulled into the driveway of the same property. Michael Den was arrested in his vehicle. In the vehicle, they found a large amount of, in another vehicle on the property, they found more large amounts. To give you an idea of the property, it's kind of a property that's got a lot of like junk on it, which is why they search things other than just the building. There are a lot of other places to search. While in custody, Mr. Den was interviewed by police. He said that the source of his is the cities, and more particular, it's a cartel connection. He said he has someone he can contact who would tell him where to go in the cities to buy. He said he buys meth kilograms at a time and splits it with other people to go sell in other places. Kilogram is 1,000 grams. He said this happened every few months. The PSI indicates that Mr. Den has 9 prior convictions. They run the gambit from defying no contact orders to receiving stolen property offenses to fighting with the police, actually. Most relevant to this, and what I want the court to pay the most attention to, would be on page 9 of the PSI, where Mr. Den described his 2000 Waseca conviction involving him conspiring to import controlled substances. That's the one that sent him to prison for 10 years back in 2000. He said that in that case, he had a connection from California who would take it to the cities and he'd acquire it and break it up with other people to do with what they want. He said he'd do it every 4 months or so. He said, I wasn't dealing, but I didn't really know what they were doing, not my problem. Quite frankly, the offense Mr. Den committed here in 2024, I think it happened in 2025, is almost exactly the same as what happened in 2000. The parallels, the similarities are shocking. the foreign connection, the picking it up, the redistributing large amounts of it to other people, and then not my business what they do with it, it's the same. He got 10 years prison for that back in 2000, and he's doing it again here, the exact same thing, using foreign connections to get a pipeline and making himself into a fire hose into the community, 1,000 grams at a time. We caught him here with 100, and the CI bought 1 gram, a mere fraction of what he described to the police. Fact is, Michael Den is a dealer. We know that because he's got the past conviction and the present conviction. And worse than that, what he describes as beyond that, it's really being a trafficker, being that middleman connection between a larger wholesaler and smaller distributors in the local community. That's his history. That's what he did here. The 10 years prisons didn't deter him. It didn't stop him. He just moved to Burnett County from Waseca instead. I think a sentence of less than 10 years initial confinement here would unduly depreciate the seriousness of this offense because of that past conviction. If we did the same punishment or less punishment for the same or similar behavior, then what message are we really sending to Mr. Den, to the community? It defies principles of proportionality. It defies McCleary-Gallion. It has to be more. That's how specific deterrence works. You ratchet up, you don't ratchet down. The repetitiveness of the facts and the offense also demonstrate to me a need for long incarceration for both incapacitation and public protection reasons. If deterrence is not going to work, if 10 years prison didn't work in 2000, then we have reason to believe that it might not work again here, no matter how much. He might come back and do it again. He still has the same connection. He could always open up shop again. He could move to a different county or just stay here and do it the same. That's why any year incarceration this court orders might save the community potentially hundreds or thousands of grams of coming into it. That's a lot of hurt and pain and suffering and potential death that could be stopped from coming here, all while Mr. Den is in custody, while he's in prison. That's the incapacitation angle. And that's time the community can be protected. I think incapacitation and public protection are really elevated in this case above the other principles we sometimes use in these cases involving controlled substances, just because of the volume and the past history. There's another reason why I think those are elevated here, and that really has to do with the defendant's overall recitation of his history. When you go through in the PSI him describing his past convictions, I think there's cause to be concerned. He's not a great target of rehabilitation and specific deterrence, because when you have an offender who seemingly either can't remember much detail about their past criminal convictions that have resulted in quite a bit of jail or prison, or they recite their past criminal history as though, I had a minor role, someone else is really at fault, where there's deflection, where someone's really to blame, then you have reason to believe that the person's not susceptible to specific deterrence or rehabilitation. Those things only happen. Rehabilitation, specific deterrence only really happen when a person is affected by their own actions through guilt or consciousness or morality or the effect of the sentence itself. The 10-year sentence didn't stop the behavior here. And when you see a person recite, either don't remember or somebody else was the main one at fault, it says they don't really have a lot of insight to their own situation. If there's deflection of blame, then that's someone, we use the broader term accountability or taking responsibility. Those have certain moral implications, but beyond that, if a person doesn't think they did something wrong, if they think it was someone else, or if it affected them so little they can't even remember it, that says that something is happening inside them, that they're not effectuating behavior change either. So there's a bigger reason to be concerned about that, in that, is this going to be another case like the past ones where it's not going to affect behavioral change because someone else is responsible, or it's not going to affect them all that much because whatever reason. And we see a little bit of that even already for this case, where Mr. Den clearly tries to say the CI planted half of it, and then the other half, which was an enormous amount of, which was still just for personal use quantity. We're talking quantities of 40 one of them was between 40 and 50 and the other was over 50 is my recollection. If the court has paused to believe that Mr. Den is likely to rehabilitate or to be specifically deterred by the sentence because of these factors, that would be more reason to, when you're balancing the different factors that it has to weigh more in the incapacitation side, more in the public protection side. And I think this is one of those cases. If a person tells you who they are, we should really be listening. And if a person tells us, you know, even after being to prison for 10 years for being involved in large distribution and doing it again, that I don't recall other things, or really I'm being framed by the CI, that should cause the court concern. I think Michael Den has told the court who he is.
Sorry. You're saying you have any?
I can't hear him very well. I don't
We have
Can't hear. We do have hearing devices, and we will have Olivia, she'll hook you up. And I can turn the system up a little bit without it screeching.
Testing. Can you hear me?
Yep.
Perfect.
Okay, so he can hear now. So Mr. Schmidt, you may continue.
Sure. I think that Michael Den has told the court who he is, both through his actions and his words. For the second time in this century, he has used foreign connections to secure large amounts of and distributed them into the community. If not directly by himself, by taking the large wholesale amounts and giving them to other people, he knows what they're doing with them. He knows what a person does with hundreds of grams of. He takes no moral responsibility for that. I noticed that when he was talking about the California connection one, the Waseca one. I don't know what they were doing with that. Yes, he pled guilty to reduced charges, but the facts of what he did are not changed. And his history is massively aggravating. If 10 years prison wasn't enough in 2000, we should be trying 15 now. He is statutorily ineligible for CIP because of his age. I think the court should make him ineligible for the ERP entirely here because of the past 10-year conviction. I think the threat of Mr. Den does not derive from his substance abuse disorder. I think it's his connections and his ability to procure large amounts of, much larger than many people are able to get for himself and others. I think that for the protection of the community, the court has to act here and they have to stop Mr. Den. That should be the purpose of this sentence. First and foremost, to stop Michael Den. Second, to specifically deter him with a larger sentence than the last one he got for really the same behavior. Thank you.
Thank you. Mr. Keene?
Yes, Your Honor. I'm just going to start with the basics. When you look at the gravity of the offense, what I think about is offenses tend to differ from a lot of the other ones. We look at the gravity. You know, for example, if you look at someone committing a robbery or an assault, or in worst cases, a murder, homicide, they aren't usually someone who's necessarily suffering from the same crimes, the same effect that we're trying to solve. For example, the reason we have laws is to stop people from using on their own and harming themselves. And Mr. Den, when we talked about his past use and his use here, you know, he was a heavy personal user. And in this case, he, sold a amount for the informant, mainly for his own habit. And, the one thing that's sort of mitigating about the offense is that generally people who look for, they find them. It's not, it's very rare that someone who, uses and or deals just goes up to random people in the community. Hey, you want some meth? I mean, it's sort of the use element. It's sort of a self-selecting community. And I'm not saying that they're in control of their actions because, almost no one who's in control of themselves would, choose the life of being a meth addict or any other, because you see the DACs, we all see what happens when people get hooked. And it's, some people are able to casually use it, but it's a hard line and it's a pretty steep fall. Now, the main area where the DA and I disagree is about the sentencing, and I think that's because we're both looking at rehabilitation. Obviously, Mr. Dent's rehabilitative needs are fairly great because, he's battled a long period of substance addiction. He did have a period in between where he was clean. He did successfully complete a 10 years of probation. It did say revocation, but it was a 17-day revocation. It mentions that in the PSI. So it's not like he was revoked and sentenced for 9 months or 2 years, et cetera. It was, what we would normally think of more of a sanction than anything else. He was discharged from that successfully. His 2018 case, he successfully completed his 2 years of probation. He had some difficulties. It mentioned about appointments. It mentioned, bringing in materials, and Mr. Dent can talk about more when it's his time. But one of the things he's let me know is that, he was in special ed and his reading is probably on the 2nd or 3rd grade level, and that his daughter had to read some of those things for him to do it. So it wasn't like some people where they just choose not to turn things in. He has reading difficulties that make it harder for him to read and write some of those things. Now, the other thing that's sort of unique about addiction is that it sort of turns our idea of specific deterrence around. Addicts have, when you're addicted, we think of deterrence as a rational thought process. If you're not functioning, suffering from addiction or some sort of mental delusion, we understand deterrence, that if you do X, you'll get Y. If you do X again, it'll be worse. When you're dealing with addiction, that thought process doesn't really apply. So I don't think the idea that, X deterrence didn't work, so this time we need X times 1.5 as specific deterrence really makes sense. Because deterrence applies to when you're thinking straight, and when you're, suffering from an addiction, the last thing you're doing is thinking clear-headedly. Now, the other things I talk about when we're talking about rehabilitation is, some of Mr. Dent's life has changed since in some of his cases. I think when you look at the PSI, it shows that up to around 2012, for the most part, you do have more of a personal history that involves violence. He appears to have aged out of that phase of his life, because I know one of the things is when they recommended 8 to 12 years of 8 to 15 initial incarceration and 4 to 5 extended supervision. One of the things they focused on was a prior history of personal violence. But if you look at his conduct since, say 2010, you can see that conduct is, faded out of his life, especially since the last decade.